Have you ever thought about how, like, the very first thing you hear about a situation can just color everything else, especially maybe in a courtroom? Well, that's exactly what we're diving into today. There's been a really critical pretrial ruling in that high-profile murder case involving rapper Charles Jones. You probably know him as Julio Foolio, right? Alicia Andrews is the defendant facing first-degree murder charges, and we've got our hands on a whole stack of fresh legal analyses and court documents breaking down this pivotal decision.
Yeah, and our mission here is really to unpack what this ruling from Judge Michelle Sisco actually means for both sides, the prosecution and the defense.
Mhm.
It really comes down to understanding what the jury hears and maybe more importantly, when they hear it and how that shapes that crucial first perception.
Okay, let's get into it then. The key date was August 13th, 2025, Hillsborough County, Florida. Judge Michelle Sisco made this ruling, and people are already calling it a setback for the defense. So what exactly did she rule?
Okay, so the core of it is this. Alicia Andrews will not be allowed to introduce evidence about alleged domestic violence during the opening phase of her trial. Now, the defense, their initial plan was clearly to weave this into their story right from day one.
Yeah.
But, well, the judge said no to that.
Okay, wow. That feels significant right at the start. You said the defense wanted to use this to sort of humanize Andrews immediately. Why is getting that out early so important for, humanization?
Well, think about it. It's all about setting the initial frame. The defense strategy was likely to provide this context, this backdrop of alleged domestic abuse, right when the jury is forming their very first opinions. This ruling really restricts that. It means the jury's first take on Alicia Andrews. It won't include this potentially mitigating information.
So their view of her actions could be quite different without that piece.
Exactly. Especially if the defense later tries to argue something like self-defense or maybe duress. It's much harder to introduce that idea later if the initial picture is already set without it.
That idea of the first impression being such a game changer in court, it really makes sense, doesn't it? It's like meeting someone, that first handshake, that first interaction, it sticks.
It absolutely does. And you mentioned duress. In legal terms, that's basically saying someone felt forced, like under threat to do something. It can sometimes lessen responsibility.
But you're saying even with that, it's tough here.
Yeah, the challenge is, while those arguments, self-defense, duress, especially linked to domestic violence, can sometimes resonate with a jury first-degree murder, that comes with a really high legal bar. The prosecution has to prove things like premeditation, a specific intent. It's a heavy lift.
Yeah.
And not being able to lay that groundwork about domestic violence early just makes it, well, even more challenging for the defense team.
Right. So a major hurdle for their opening strategy. But I heard the judge didn't completely bar the evidence forever. There's some kind of conditional exception.
That's correct. It's not a total ban. Judge Sisco left let's call it a small door open. The defense might be able to bring in the domestic violence evidence later on, but only if the prosecution, through their questions or the evidence they present, somehow makes it legally relevant at that point.
Okay, so it depends on what the prosecution does.
Pretty much. They have to open the door, as lawyers sometimes say. It means the defense can't proactively bring it up when they want. They have to wait and see if the prosecution's case creates a specific legal opportunity.
So for Alicia Andrews' lawyers, this means they really have to adjust. They need to play more of a waiting game.
Exactly. They have to be patient, strategic, hold back some key information, perhaps, and wait for just the right moment, that specific legal window to potentially introduce it. It's a big shift in tactics.
Okay, let's flip this around. What does this mean for the prosecution? How does this ruling actually help their strategy?
Oh, it's a significant strategic advantage for them, no question. It basically allows them to present their version of events first, to shape that initial narrative, without having to immediately deal with the complexities or counterarguments related to domestic violence.
So they get to focus the jury's attention solely on the murder charge at the start?
Precisely. They can build their case, focusing on the elements of first-degree murder, and the jury hears all that before they hear anything about the alleged abuse. It lets the prosecution control that crucial early framing.
Interesting. And what does this decision tell us, if anything, about Judge Sisco herself and how she's likely to run this trial?
Well, it suggests she intends to manage this case very carefully, with quite tight control over the flow of information. It signals she's focused on procedure, on ensuring evidence comes in at the legally appropriate time and in the right way. It points towards a very methodical, deliberate approach to the trial proceedings, making sure the jury hears things when they're supposed to, legally speaking.
Okay, a methodical judge, a strategic advantage for the prosecution, and a defense team needing to adapt. What's the very next step we should be watching for?
The immediate focus shifts to jury selection. That's scheduled to kick off on Monday, August 18th, 2025, right there in Tampa.
And that's obviously huge. That's where the groundwork is laid for who will actually be deciding the outcome.
Absolutely. Both sides will be working intensely to select the jurors they believe will be most receptive to their case. It's a critical phase.
And then the trial itself sounds like it's going to be complex. High-profile witnesses, forensics, tough legal arguments back and forth.
Definitely shaping up that way.
So to wrap up, this ruling really underscores how a trial isn't just about the facts, but about the timing and presentation of those facts. That first impression is powerful, and the defense now has to play a much longer, more reactive game.
That's a great way to put it. And it leaves you thinking, doesn't it? Beyond the courtroom, how often do we form strong opinions based on incomplete information presented early on? It really highlights that in any situation, not just a trial, when and how we learn things can dramatically shape our understanding, and changing that initial view later. Well, that can be incredibly difficult.